That means we've got to wait for the stream to fire up all across the fruited plain of the interwebs. Before we go ahead and get started, we got some opinions to dig into. We got a McAfee opinion, we got a Cannon opinion, and we got an affirmation from Todd Blanche that we are about to get into, but the tubes have to connect themselves first. It looks like they've done that. That's tremendous. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Judge McAfee. He's starting us off. A ruling came down from him responding to a Trump request to dismiss the Big Fanny RICO case. Of course, the 19 co-defendants charged with a slew of different crimes. They wanted to dismiss this, saying that Trump had a First Amendment right, free speech, guaranteed under the Constitution, to do his job. Remember, he was the president at the time, and so he has to talk to people. He has to say things. He has to do things. He has to call people to have conversations with them about governing. He has to talk to his Department of Justice team, people who are at state level, local elections, and so on, people like Brad Raffensperger and whatever. But Trump said that is protected. Okay, these are official acts, and the First Amendment precludes the possibility of criminality for doing something that is protected. So they submitted a motion to dismiss. Judge McAfee has come out and denied it. Now, this is not going to be a big surprise. All questions about how this is going to go from Judge McAfee after whatever that excuse was of a ruling from him, where he said, you know, only one bank robber is good. Two bank robbers are too bad. Like, that's not salvageable. But if you only have one, well, that's okay. Some criminality will remove the taint, but too much criminality will bring back the taint from Fannie and Nathan Wade. So McAfee denied the motion. Again, not a surprise. Probably going to continue to be this way from this guy who says he's not biased, but we'll see. We've also got an order from him, and Steve Sadow responded. Okay, so Trump's defense has already come out and said, you know, there's a little opening in here on this. They think that Judge McAfee gave them the possibility of refiling this because it was not denied with prejudice. It was denied without prejudice, which means they can try it again. And so Sadow is intimating that what may happen is they'll lay some factual foundation for this at the trial and then maybe renew the motion, saying that it is now going to be ripe for review. So we'll go into that. We'll see what's happening there out of Georgia. There's a bunch of stuff going on there. There's the young thug trials, ridiculous. And Fannie's office is just a catastrophe. So we'll get into that. Then we're going to see what's happening in Florida, because Trump also got hit with a rejection kind of today. We'll talk about this because it is technically a rejection, right? We've been here covering these filings from Trump's team in the classified documents case, and they have submitted a whole slew of them. We're waiting for rulings on them. So far, they've all been denied. And this is not a surprise, by the way, okay? In criminal defense law, very common, right? Most of your motions to dismiss are going to be denied. In fact, like 99.9% of them are. But that's okay. You only need one, right? And that's it. The whole, can deviate the whole case, make or break the case. So we're expecting this. We're not expecting, Cannon to come out and just dismiss it on the first shot. But this is another rejection from her. But again, kind of, okay? Because what we're talking about is who gets to make this decision. Do the jurors get to make this decision, or does Judge Cannon get to make this decision? Is this a question of law reserved for the judges, or is this a question of fact and something that the jurors should be able to decide when they hear the case and come to their own conclusions? Now, Jack Smith is wanting the judge and the court to basically take that decision away from the jurors and to say that Trump is precluded from having the Presidential Records Act even apply to him. And we read through Jack's screed yesterday, and I got some clips on this. Even Elie Honig from CNN's like, yo, take a breath, bro. Relax. Just calm down over there, Jack. Stop being hysterical, okay, you deranged thug. So Jack was all in a hissy fit about this and saying that we're going to appeal you. And Cannon said, well, you're not doing that right now. I'm not going to give you a ruling, even though Jack Smith was threatening her, basically. We need a ruling so we can appeal this right now. She said, no, not going to do that. Sorry, Jack. And what ultimately this does is actually, if the possibility is still open that the jury instruction that Cannon proposed previously, which would be absolutely devastating to Jack Smith's case, might actually be valid, right? She might be still considering that. And then when we get to the appropriate time in the trial, when we're having our charging, meeting, and we talk about how the jury instructions look, that's when we would get into this again. So got a couple of clips on that segment, and we'll jump into all of that. And then, man, this filing just hit. This was actually filed some time ago, but it just hit, I think, because it is now part of the conversation about the trial date in the New York case. Of course, Alvin Bragg prosecuting Trump. Trial scheduled on that one, like less than 2 weeks from now, 11 days, starting on April 15th. And it's looks like it's going, okay? Looks like it's actually going to be happening. And this could be very curious. So this has now come out, and I just pulled this from Blanche Law. I think he just dropped it on his website, because Blanche Law has all of his filings, by the way. If you want to go check that out, you can. I encourage you to do that and spread the filings far and wide so that people can see what's going on here. He has them right on his website. So he just dropped this one, and it's an affirmation from him, from Todd Blanche, that is explaining the collusion between these two judges. You know who they are. Judge Juan Merchan and Judge Chutkan over on the DC case. And so Todd Blanche, Trump's defense attorney, submitted this affidavit back to the court, and he said, look, why don't you make your little conversations amongst yourselves public? Why don't you add those to the court record so that we can all see what you guys are talking about? And we already know here, we've covered this previously, Judge Juan Merchan has already denied opening up the public record. Okay, Trump said, can you please just put everything on the docket, including your little emails back and forth with everybody? And he said, no, it's all already public, and we've gone through unprecedented steps to publish a couple documents and whatever, right? So turns out they were colluding. The affirmation of Trump's lawyer, Todd Blanche, says, I know you were, so why don't you tell us what you were talking about? Because remember, Merchan's case was on hold, right? It was taking the back seat. They had 3 other cases that they thought were going to go to trial until all of those got deviated. Then they just leapfrogged. They brought Merchan's case back to the very front, and that's scheduled for trial because they are freaked out. We've got that. We've got then Alan Dershowitz, who's next door on YouTube and basically everywhere. He is saying, I've never seen anything like this in like 60 years, talking about this New York case. And so I wanted to play that for you. He's been around a while, and he's telling us, never seen anything like this. And it's bizarre, right? This is a zombie case that is crazy. And I'm working on actually some slides that is consolidating the timeline, right? Where did Matthew Colangelo come from? Matthew Colangelo started with Obama, then he worked with Tisch, then he worked with Biden, then he worked now for Bragg. He's bounced around all these different places, and basically every time, aside from Obama, he has been going after Trump, and that was only because Trump was not on the scene yet when he was with Obama. So, trial's coming up. Trial is not going to be televised. There was a question from Janek. Trial should not be televised in New York, but we'll be covering it here, right? We're going to be digging into some of those X-script threads, and whoever's reporting it, we're going to be trying to recreate the trial as best we can. So, as you can see, my friends, it is a beautiful, beautiful day. It's an amazing Thursday. I hope you're having a beautiful week. We had an amazing members-only stream this morning. We like to get our day straight with our membos on the morning streams. And so it's a great way to kind of figure out what's going on in the day. You probably have heard of some of these other, like the New York Times has like the daily, whatever they call it. It's like the 20-minute podcast or whatever, like whatever they think's the highlights. So, it's like that, except much better, a lot more intelligent, and we cover more ground, and it's on video, and there's membos there. It's just great. So, think about, Politico has like, what do they call it? The playbook, where they hit, just quite quick snippets, bounce around. That's what we do. But we do it with our membos. We have a little bit more of a casual conversation. We get started in the mornings, 9 a.m. West Coast, noon East Coast. Not really morning for you guys, but good to see you. So come and join us. And we have streams on Saturdays, and we do members only after parties and all the things. It's a lot of fun, and it's a great way to support our show, meet some people, and stay connected. Loneliness is like killing people now. Don't be lonely. Come join us. All right. We got this one from Robert Govea. This is our website. Our PDFs are there. Our newsletter's there. Our show calendar and the court watch list is there. We have whatever, there's a lot. I can't even remember it all. That's how much stuff is there. So just go check it out. robertgovea.com. And of course, watcherlodge.com. Check out the calendar. Go to watcherlodge.com and sign up on Saturday. We're starting our first Sovereignty Saturday. Okay. Every Saturday between now and the end of the year, we are dedicating to sovereignty. Okay, we don't know what the heck's going on with this next election, so we're getting prepared. We have, I'm already getting my vertical garden ordered, and we're going to start talking a lot about sovereignty stuff. So come join us, watcherlodge.com, all free, Sovereignty Saturday. Just, it's a different place to house this content and this conversation, so come join us. All right. And that, my friends, is it for us on the day. And I'll see if I can, yeah, all right. So we'll come back on that. Now, here, without any further ado, is where we're getting started on this incredible Thursday. Judge McAfee denies Trump's motion to dismiss. Not a big surprise. Judge McAfee, who let us down, he told us he was going to rule with integrity and that he had an honorable court and he was dedicated to the profession of law and all this crap. Turns out, doesn't really care. Fanny sits down in his courtroom and perjures herself in front of not only his face, but all of America. But anyways, we know that, McAfee's probably not going to let this case go away. Probably got the instructions or the pressure from somewhere. This thing is staying right on track. Don't you dare touch it. And so this case is moving forward. Trump submitted a motion to dismiss it because of the First Amendment. Trump, of course, the president at the time when all of these allegations came about, they said he was investigating the election illegally. And Trump says, no, I have free speech. I was the president. That means I can talk to people who are involved in the investigation. And so we're going to go through and see why McAfee says that is not sufficient to dismiss the case. But Steve Sadow has already responded to this, right? This is the Trump defense attorney who is like a bulldog there in Georgia. And he was already on X today explaining this is not that big of a deal per se. I mean, obviously, you like to get your case dismissed, but motions to dismiss the entire case, they are far and few between. You only need one, which means 99% of them don't go anywhere. So here's what Sadow said immediately after this ruling came out, saying, not that big of a deal because we might be able to raise this later on down the line. Saying, here's my statement as lead defense counsel for President Trump in the Fulton County, Georgia case. He says, we respectfully disagree, much nicer words than we have, with Judge McAfee's order, which is refusing to dismiss the indictment, and we'll continue to evaluate our options regarding the First Amendment challenges. It is significant, though, says Sadow, that the court's ruling was without prejudice, meaning that this can be brought up again, as it made clear that the defendants were not foreclosed, were not prohibited, not precluded from again raising their, quote, as applied challenges at the appropriate time after the establishment of a factual record. Okay. So it's a little bit of a punt then, saying, well, I'm not seeing anything right now facially that says that Trump's First Amendment rights are being violated. But it's because we haven't seen any facts yet. And if we start going through this trial or see this later at an evidentiary hearing, or this comes out some other way, then maybe it can be submitted again, right? Without prejudice means you can do this again. With prejudice means it's not coming back, right? Don't ask again. So that is from Sadow. Now let's get right into the opinion and see what McAfee had to say. Scott McAfee, Fulton County Superior Court, state of Georgia, the big Fanny case against Donald Trump and the other co-defendants. This is from Scott McAfee himself, the same judge who said, no problem with Fanny as long as Nathan goes, you can stick around and continue to be tainty and have an odor of mendacity in my courtroom. Whatever, he doesn't mind the smell. Order on Trump's motion to dismiss. Trump submitted a motion to dismiss, saying First Amendment protects me. They argue that Fanny violates the First Amendment's protections of political speech and activity, violates freedom of association, the right to petition Congress as to their alleged misconduct. And further, Trump says, these indictment charges are way overbroad. After considering the extensive briefing, the argument of counsel, the indictment, Judge McAfee says, the court finds these vital constitutional protections do not reach the actions and the statements that are alleged by the state. Right. So Fanny said that there was criminal conduct. Now, it's always important to get clear on what the criminal conduct is. And we'll see if the judge does this. I'm sure he will. But in the indictment itself, right, it specifies specific actions that were taken. And Trump is saying those actions are put inside this force field of the First Amendment. The judge says, no, they're not. They're outside of that. nor did the statutes themselves violate the First Amendment. So the law is not bad. So both Fannie's charges in the indictment don't encroach upon the First, and the statutes themselves are not unconstitutional as written. So sometimes laws are unconstitutional. So for that reason, both of the motions are denied. Here's what McAfee says. It says, abridged to a basic description. So let me give you the cliff notes on this. The First Amendment means that the government has no power to restrict expression because of its messages, its ideas, its subject matter, or its content. And that laws regulating speech outside categorically excluded forms of expression are subject to exacting scrutiny. Okay, so this is the power of the First Amendment. We recognize some things are outside of the First Amendment and not protected, and so on. Now, although a First Amendment is a, quote, broad umbrella that shelters all political points of view and shields a wide range of avenues for expression, free speech, including political speech, is not without restriction. Several narrowly defined forms of expression are categorically excluded. And when such a categorical restriction applies, levels of scrutiny have no analytical impact. So, in constitutional law, we talk about this concept of scrutiny. And when the government does something, we ask, how can we scrutinize it? And how hard should we scrutinize it, really? It's like, if mom says, did you clean your room? You say, yeah, I cleaned my room. Right? Is she going to go check hard on that, or going to kind of take your word for it, give you the benefit of the doubt, say, probably good enough, we'll take his word, right? Leave it alone. Or is she going to go in there with a, microscope, look under the bed, in that drawer, want her in, all the things, is it going to be a high level of scrutiny or a low level? The high level of scrutiny we call strict scrutiny, right? In other words, the government needs to be examined extremely strictly. And if their conduct infringes on a constitutional right, we look at it and say, whoa. But if there is a categorical, exemption to that, then we don't really have to bounce around on that. Like fighting words, for example, incitement to imminent, offensive conduct are things that are precluded. Now, these excluded categories include speech that is integral to criminal conduct, right? So speech that is necessary to be a part of the crime. So like if you solicit someone for a sale of drugs, hey man, you got any crack I can buy? Hunter Biden. Hey man, you got any crack I can buy? It's the White House. I'm the first son, give me some crack, right? Hunter can't turn around and say, well, that's just my free speech rights. No, it's solicitation of crack that you forgot in the White House. So if it's part of the crime, then it's that's not protected. No fraud, no speech, or presenting an imminent threat, that the government can prevent, right? So imminent conduct. Now, restrictions on speech that are, quote, speech integral to criminal conduct have never been thought to raise any constitutional problems. So if you pass a statute that, is criminalizing that, it's not illegal. Speech or writing that is used as an integral part of conduct that's in violation of a valid statute is not protected, nor is a false statement which threatens to deceive or harm the government, right? So if you lie, you can't turn around and say, well, that's my free speech, like on government benefits or something. Now, the First Amendment's freedom of association also includes the right to associate for the purposes of engaging in those activities protected by the First Amendment, which are speech, assembly, petition for grievances, exercise of religion. Now, this protection encompasses a political party's decisions about the identity and the process for electing its leaders, right? That's the association, get together and vote. But like political speech, the right of association is also not immune from restriction, particularly where the state indisputably has a compelling interest in preserving the integrity of the election. Right now we're asking ourselves, okay, what is the state interest? This helps us analyze the level of scrutiny. Okay, what is the state interest? And what are they infringing upon? If they're not infringing upon your constitutional right, if they're just passing a law that doesn't infringe on anything that you're protected under by the First Amendment, then we just call rational basis review. As long as they have a rational basis to do it, they can go and do it. Nobody even bats an eye. But if they're going to be impinging on your constitutional right, then we have to look back at the government. We say, well, wait a minute. What are they trying to accomplish? What is their interest in impinging on your right? Here, they're saying, oh, it's the election. So, okay. So now it's speech versus the government and their right to maintain an election. And thus laws that are burdening the associational rights of political parties may also be valid, right? So laws, sometimes that might infringe your right to associate, could be valid. We don't know. Now, similarly, this is Judge Scott McAfee writing, denying Trump's motion, but leaving it open for a re-review, says, similarly, the protection afforded by the petition clause of the First Amendment that ensures the ability to communicate one's will to government officials is regarded as implicit in the very idea of government, this Republican in form. It also doesn't extend to allegedly fraudulent petitions, right? So you can't say, I'm going to petition my government for a redress of grievances and then file, a fraudulent claim with them. No, that's still fraud. In other words, the law does not insulate speech allegedly made during fraudulent or criminal conduct. You're not protected from prosecution under the guise of petitioning the government. The right to petition is not absolute, nor does it carry special First Amendment status that would render any claims asserted under it immune from criminal recourse. So he says, now, with all that being said, let's turn to Trump's arguments with these guarantees in mind. Says Trump's generally seek dismissal on the basis that it does violate Trump's First Amendment rights. He was simply contesting the election. Saying Trump's constitutional challenges sound like this, summarized as follows. Says Trump's challenge to RICO is facial, says it's not even applied appropriately because count one is about Trump's speech. It's about his petitioning the government. He was out there saying, this was a rigged election. This was a fraudulent election that was stolen. He has a right to say that and to petition his own government, even as the president, to say, hey, Congress, idiots, do something. And assert that every predicate act, right? So they say, Trump is saying, you're violating my free speech. And every act that Big Fanny is alleging was something that was contributing to this conspiracy. The first count was the conspiracy, the RICO count. And then there were a bunch of other charges, and then there were the overt acts done in furtherance of the conspiracy. But they say, Trump says, no, it's all protected. Okay, there's this big umbrella conspiracy and every other sub-overt act under here, all protected because this whole thing is protected by the First Amendment. Saying Trump also argues that this statute that Trump was charged under, which said that it's a crime for an individual to, quote, falsely hold himself or herself out as an officer with intent to mislead another into believing that she is or actually is an officer. They say, Trump says that's unconstitutional as applied to their conduct. Because these various defendants, okay, not just Trump, by the way, other defendants were in charge with impersonating a public officer. These are the people that were allegedly, according to Fanny, they were holding themselves out as the alternate electors, but they weren't actually alternate electors, according to them. So they say that was also unconstitutional because that was their involvement under the First Amendment with the right of association. They say the defendants in this case also challenge this provision, this charge, talking about altering and making fraudulent adjustments to these writings. Okay, and so there were different documents that they wrote, and they actually put this in. They signed a document of alternate electors, and they sent a memo also in, right? They sent basically two documents in that said, we're alternate electors, hold these in, and they're being charged under those filings. Similar here, okay, this indictment alleges that Giuliani and others made false statements to the Georgia Senate. And they say, wait a minute, false statements to the Georgia Senate? That's just us petitioning our government. They say, no. Those were false statements in your petition. You used a false document. You conspired to willfully file false documents. They weren't actually the presidential votes of the electors and false certificates and all these things. So they say here, this is McAfee writing. Now, as applied, here we go. See this one right here. This is kind of the escape hatch. Now, as applied, constitutional challenges typically rely on the development of a factual record after trial. After trial. This is him just kind of hinting it's a little early for this. Yet our Supreme Court's decision demonstrate that as applied challenges may be considered pre-trial if we have a limited record at hand that we can use. So he says, normally we do this later, but we can do it now. And other cases say that I can do it now, so we are. And so this court therefore follows that path, and we hold to our position that nothing is stipulated or agreed to beyond the grand jury's averments and the four corners of the indictment. Okay, so the judge is saying, look, the only thing that I can really go off of now is what is in the indictment, right, on this issue. I got no other evidence, and I can listen to what the grand jury says. That's it. They say, after interpreting this indictment's language liberally in favor of the government, Fannie, as required at this pretrial stage, because if they're going to dismiss the case, you got to look at it in a light most favorable to the non-moving party. So defense says, let's dismiss. They say, well, if we look at it in Fannie's interest and we can still dismiss it, then we have to dismiss it. So he says, well, let's look at it in Fannie's light. Says the court finds that Trump's expressions and his speech are alleged to have been made, according to Fannie, and we got to give her the benefit of the doubt for this process. She says they were made in furtherance of criminal activity. And she says that they constitute false statements, knowingly and willfully made within the government's jurisdiction to deceive them. Now, even core political speech that addressing matters of public concern is not impenetrable from prosecution if allegedly used to further criminal activity, and citing other cases there. And independently lawful acts involving speech within the meaning of the First Amendment may nonetheless suffice to support a RICO conspiracy prosecution. Nor is a false statement knowingly and willfully made in a manner within the government's agency's jurisdiction and which threatens to deceive this government free from restrictions either. Right? So in other words, there's precedent that if you're lying to the government, they can charge you for lying to the government. You can't call it a petition. The court in Haley declined to interpret it this way, that statute, as a broad criminalization of false statements. And so viewing the indictment here from Fannie most favorably to Fannie, McAfee says the court finds that First Amendment exclusions are applicable to the conduct under pertinent statutes, under the pertinent statutes. So it is excluded from the force field protection of the First Amendment. Saying during oral argument, Trump posited that the speech at issue, even if it were false, was political and that one cannot be prosecuted for falsity alone. Right? Trump says, well, what if I went in there and it was political and it wasn't true because it's politics. Like, who knows what's true? We have debates over global warming all the time. They say they're true. I say they're not, right? And the list goes on and on. Pick whatever you want. They trust the science. What science? The same science that's giving us all these results now? Okay. Got it. Thanks for that. Right? So, like, what is true? What is false? And if you're making a claim that the election was rigged, how do you decide that, right? Who's the final arbiter of that to say, well, maybe it was rigged. Maybe it's not rigged. Who knows? So he says, but Trump's people are saying, yeah, even if it was false, that's political, right? Like, you're allowed to be false in your political speech. That's not a crime in America. However, unlike the statute at issue in Alvarez, right, different case, the state's allegation do not suggest that this prosecution from Big Fannie comes solely because it believes the speech was inaccurate. The prosecution does not result in merely restricting false speech. Instead, the indictment averts throughout the indictment that the defendants acted willfully and knowingly and that they impacted matters of government concern. These are not legal conclusions, but these are issues of fact. We send those to the jury. Now, the allegation that Trump's speech or conduct was carried out with criminal intent or something that only a jury can solve. Yeah. Accepting the allegations is true for the purposes of this pretrial challenge. We're not quite there yet. As the court must hear, the speech alleged in this indictment is integral to criminal conduct. That's how Fannie charged it. And if she charges it that way, it's categorically excluded from the First Amendment. Now, to the extent that the alleged acts or the speech were directed to public officials, the court nonetheless determines that this charged conduct does not unconstitutionally burden the right to petition, right? Trump says, I was literally petitioning, Congress to investigate. That speech is used as a tool for the fact that speech is used as a tool for political ends does not automatically bring it under the protection of the First Amendment. For the use of the known lie as a tool is at once at odds with the premises of democratic government and with the orderly manner in which economic, social, and political change is to be effected. Calculated falsehood falls into a class of utterances that are no part of any societal benefit and doesn't create order and morality. So we're not protecting those falsehoods. This is from a concurring opinion in McDonald versus Smith. Supreme Court case 1985, citing another case from 1942. Now, the state, says McAfee, continuing, the state has alleged more than mere expressions of political nature, right? Fannie's indictment's huge. Rather the, just, like Fannie, says, rather the indictment charges, she's the biggest Fannie in Georgia, as we talked about. The indictment charges the defendants with knowingly and willfully making false statements to public officers, knowing and willfully filing documents containing false statements. Those are the alternate, elector documents. So it's not just speech, it's also filing, right? Also misrepresentations and so on. Now, the defense has not presented, nor is the court able to find, any authority that the speech and the conduct is protected political speech. Like, is the conduct also protected speech? Although Trump and the defense characterized the relevant speech and actions as petitions to Congress about the validity of the electors, which must be afforded the constitutional protection, at this stage, right, the court must consider the method and the manner of the criminal enterprise as alleged in the indictment. So I can't really give you any benefit of the doubt right now. Now, having done so, the court concludes that the petition clauses protections do not extend to the case at hand, saying Trump also raises facial challenges to the Georgia law, saying these statutes criminalize all manners of false, fictitious, and fraudulent expressions, even some that might be protected, saying they're overbroad, right? They criminalize too much conduct, some that's legal. Overbreadth is a form of facial challenge that gives the challenger standing to argue a statute prohibits a substantial amount of protected speech. Covers too much. Here, the defendant, Elie, argues that together these statutes criminalize all false statements and all false documents. But he says, no, that reading overstates the scope of the conduct that is actually prohibited. Because both of these are limited in their reach, neither justifies applying the strong medicine of the overbreadth doctrine. And in addition, Judge McAfee sees no reason to depart from the Georgia Supreme Court ruling in that case. Denied a similar challenge there. The statute does not blanketly apply to all instances. No, it's actually knowingly and willful false statements made within a government agency's jurisdiction. And so it says it's within their jurisdiction. It's not overbroad. And it means they're the things that they work on, the things that they do. Not like the jurisdiction of Arizona. So the court's logic applies here, saying the statutes themselves are not overbroad. And defendants, Trump and others, they rely on this case that says prohibitions on false political speech must be subject to the highest judicial scrutiny because political speech is afforded the most protection. But whereas the challenge in that case criminalized participating in political advertising or campaigning which spread known falsehoods, implicating strict scrutiny, the pertinent, which is the highest level that we talked about, the pertinent statutes at hand, when considered facially, do not aim to regulate the discussion of public issues at all. And further, the statutes do not facially violate Trump's freedom of association. Our Supreme Court has upheld legislation that impacts the right of association after you balance the government interests with the integrity of the democratic process and ensuring that against a fundamental, balancing that against an individual's fundamental rights. So compared to legislation like that, which was much more problematic, the statutes here in Georgia only incidentally touch, assuming that they do at all, Trump's right to association. And so therefore, the state retains its interest in preserving the integrity of the presidential electoral process. While they retain that, the risk that doing so will override any implicated rights to association is legally immaterial. So, Judge McAfee, here you go. There's the final sentence that really matters. Without foreclosing the ability to raise similar as applied challenges at the appropriate time after the establishment of a factual record, Trump's motions to dismiss right now are denied. So ordered April 4th by Judge McAfee, Fulton County, Big Fanny's courtroom. And so it's technically a loss for Trump, but I think it's still a valid issue that they will re-raise. And as Steve Sadow has explained to us already, they are going to consider how to do that. So we'll be here waiting to cover any of the new filings that drop on this one. We still have a whole long road ahead of us in the Fani Willis prosecution. And so, my friends, thanks for joining us when we cover this topic and others. Thank you for subscribing wherever it is you're watching this. We got some great links down in the description below. Our members only community is live, watchingthewatchers.locals.com. We have an amazing group of people there. We do streams in the morning, streams on Saturday. We talk about all of the other political affairs and some of the legal stuff going on that we can't get to here. We'd love to see you over there. And of course, right back here on the next one. All right, my friends, now let's carry on. We got some Florida updates, and we're going to see what Jack Smith has to say about this because he's very upset from yesterday. Jack Smith gets rejected by Judge Cannon in Florida. Remember, he sent her kind of a threatening little nastygram saying, hey, Cannon, we need a ruling now on these jury instructions because if you don't do them the way that we want you to do them, we're taking this up on appeal. We're going to the circuit court and we're going to have them reverse you and you're just going to have to deal with it. And so Jack Smith sent in this ranting kind of screed to her and he told us that, first of all, Trump has no right to say anything is protected under the Presidential Records Act because Trump didn't invoke it, right? Trump didn't fill out a form and give it to somebody in the White House before taking the documents. And of course, we know that that's not required at all because of Bill Clinton and the sock drawer case where Judge Amy Totenberg explained. Amy Berman Jackson explained that that was the standard. No one can question a president's decision, right? The actual Presidential Records Act gives the president the right to defend, the right to have discretion over those documents. So even CNN and Elie Honig agree that Jack Smith should just calm down a little bit. All right, just take a breath, dude. Relax. It's not that, end of the world. All right. This is just normal practice of law stuff. And Jack Smith doesn't have the right to go and scream at a federal judge and tell her to get me my jury instructions right now. Who do you think you are, Jack?
How rare is it to see this filing from the special counsel taking a very aggressive tone?
Well, Wolf, it's exceedingly rare to see a prosecutor express this type of frustration so directly, so unapologetically. And I have to say, I understand to an extent where Jack Smith's coming from. When I was a prosecutor, I had occasional moments when I was very frustrated with judges. Ordinarily, what you do is you take a deep breath and you take it down a notch or two. Jack Smith apparently has not done that. But the reason he's so frustrated here is because Judge Cannon seems like she's entertaining the idea of instructing the jury at trial on this Presidential Records Act defense, which, as Paula, I think, just very nicely laid out, lacks basis in fact or law. And the other source of frustration for Jack Smith that's palpable is he can feel the trial date slipping away. It is getting less and less likely every day to the point where it's almost an impossibility now that this case will be tried before the election.
Oh, man, that must have hurt for those CNN viewers over there. Almost an impossibility that this case goes to trial. which is why Jack Smith was so ranty yesterday. And we read that one here, and it's very fun when CNN agrees with us. We're like, gosh, a lot of people on the left were saying, Jack Smith is so heroic. His filing is so amazing. All the same Luddig type people who were dead wrong, 9-0 reversals out of the ballot removal case. They were all enamored with the filing. And we're sitting here going, what? It's even logically inconsistent, internally incoherent. He says it's a legal issue that she needs to decide right now. And then he goes through a bunch of facts, like pages of facts that we say, wait a minute. It sounds like you think that the jury should decide this. So maybe the jurors should know all about the Presidential Records Act, right, Jack? Why do you keep talking about all these facts as though they're not important? And it seems to me that if you think that these facts would change the equation, right? Like if Jack Smith's argument was that if Trump invoked the Presidential Record Act protection, the privileges, he should have told somebody or wrote it down or whatever, and he interviewed a bunch of people and nobody heard, whatever. And Trump never invoked it. It's like, oh, okay. Does that mean that he broke the law? No, you still have the power, right? The power belongs to the president. He doesn't have to fill out a form. Otherwise, the person who fills out the form is the person who is the decision maker, right? They get to approve it. There is a safety valve on it. And this has already been decided by Amy Berman Jackson in the DC circuit with Bill Clinton. He didn't turn documents in. Okay, like that's it. If you turn it in, then it gets counted as a presidential record. If you don't, that's it. They're yours. Take them home. Put them in your briefcase. Take them home. And that's what happened with Bill. So Jack Smith is now freaked out about this. And what Cannon is going to do is going to deny the request to dismiss the case. But practically, okay, the reason why Jack is so irritated is because if she includes this jury instruction and the jury gets the instruction that we read here, the jury's going to dismiss the case. All right. So basically, Cannon doesn't need to really make that decision. The jury will do it because the instructions are so obvious that the Presidential Record Act applies to the president. That's like a bonehead. You're like, oh, wait, it says here the president can make the decision. He's got full discretion to do it. No one can challenge. Clear as day, not guilty. So yes, Cannon denied dismissing the case, but she's leaving this open. And this is why people are very upset about this on the left. They're saying, she's just out of control. It's time to appeal her now. So here is a very short order from Judge Cannon responding to Jack Smith's whiny screed that we covered here previously. And Cannon responds, she says, all right, look, here's the order from the case in Florida. Says, here's the order denying Trump's motion to dismiss the superseding indictment based on the PRA, the Presidential Records Act. She says, this matter comes before the court on Donald Trump's motion to dismiss. He wanted to dismiss the indictment based on the Presidential Records Act. We've covered that. Now, the motion is brought pursuant to the law, says that there is a failure to state an offense, right? It's not a crime if Trump had the documents, if the Presidential Record Act applies, so they can't charge him. It seeks dismissal of counts 1 through 32, which are all the documents. Those counts charge that Trump willfully retained and failed to deliver the documents that contained national defense information accordingly, right? It's a retaining of those specific documents. Now, the motion from Trump also seeks the derivative dismissal of the remaining counts, right? How can you have obstruction if your possession of those documents was lawful? Jack Smith opposes the motion. Court heard oral arguments on this just over 2 weeks ago. And here is what the judge says. Now, fully advised in the premises, Judge Cannon writes to Jack and Trump, the motion to dismiss this case is denied. Says bound by the four corners of the indictment, right? That's all the evidence she can look to. And on a motion to dismiss, she looks at it in the light most favorable to deranged Jack. Says counts 1 through 32 track the statutory language and the essential elements of the charged portion of the crime, making it illegal to have unauthorized possession, right? So she's breaking the elements out for us. So making it illegal to 1, have unauthorized possession of 2, any document. Did Trump have any document? Yeah. Relating to the national defense. Did they relate? Yeah, okay. And to willfully retain and fail to deliver to someone who's entitled to receive it. It says, okay, so that's the elements as charged under 793. So Does the indictment match that? Those same counts make no reference to the Presidential Records Act, nor do they rely on that statute for the purpose of stating an offense. So it's a defense. It's not a failure to state an offense, right? They're stating an offense, but the Presidential Records Act would be a defense under that. Now, as for the remaining counts against Trump, they too track the applicable language. More generally, the superseding indictment specifies the nature of the accusations against Trump in a lengthy speaking indictment. Oh, that's a little jab at Jack there. Yeah. Why is it so lengthy, Jack? Why is it such a speaking indictment? With embedded excerpts from investigative interviews, photographs, and other content. Why? It's because Jack was writing this for America, for Liz Cheney, and for the media. It wasn't just a list of charges with a description of the date, time, location, jurisdiction, element, the statutory references and the various elements there. You see it, right? The count, what it won. No, it's a whole thing. So she kind of calls him out on that. Why was that? So for these reasons, accepting the allegations as true, the Presidential Record Act does not provide a pretrial basis to dismiss any of those counts. Now, separately, to the extent, right, this is where Judge Cannon's going to say, all right, Jack, now it's on to you, buddy boy. Separately, Jack, to the extent that Jack demands an anticipatory finalization of jury instructions prior to trial, prior to a charge conference where you do those things, and prior to the presentation of trial defenses and evidence, the court declines that demand as unprecedented and unjust. You idiot. Right? Jury instructions, as we've covered many trials here, depend on what happens at the trial, right? And Jack Smith says, I want him right now, and we want him now, otherwise I'm going to appeal it. And she's just told him hard no. Sorry, dude, no. It would be unprecedented and unjust. So the court's order soliciting preliminary draft instructions on certain counts should not be misconstrued, Jack, as declaring a final definition on any essential element or asserted defense that, in this case, nor should it be interpreted as anything other than what it was, weirdo, a genuine attempt in the context of an upcoming trial to better understand the parties' competing positions and the questions to be submitted to the jury in this complex case of first impression that's never happened before. As always, any party remains free to avail itself of whatever appellate option it sees fit to invoke, as you're entitled to under law. Jack, go ahead, appeal me, punk, I don't care. Have fun, appeal it if you want to. All right, so all the weirdos last night who were doing backflips, yeah, Jack Smith playing hardball now. This is the kind of Jack Smith I'm looking for, right? Just go on their YouTube channels. Jack Smith slams cannon, no more softball, idiots. It's ridiculous, right? We didn't even read through the full thing yesterday. Couldn't even get through it. I'm like, oh, what is this dude talking about? He's logically inconsistent. He says that it's only a matter of law. So Jack Smith wants to just, basically throw the Presidential Record Act applies to everybody except the president. President Trump, at least. Applies to all the other presidents except him. So it's ridiculous. Now, Cannon just gave him the old backhand and very short opinion. And what she's doing here is, I think, exactly right. So she is saying, we can consider this, right? We're going to revisit these arguments, these jury instructions later, but this leaves open the possibility that the original instructions make it to the jurors that we read here. And the original instructions talk about the Presidential Records Act. So although the case is not being dismissed on the back of the Presidential Records Act, she might be able to just show the jurors, hey, here's the Presidential Records Act. See this thing? Here's what it says here. Here are your jury instructions. It says mandatory. You cannot deviate from a president's discretion on how this works. Jurors say, oh. So the jurors dismiss the case, which is why Jack Smith was so ranty about this. And Jack Smith is also hysterical because he doesn't want this to be delayed anymore. If he has to appeal this up, that's going to slow down this case even more. And he's just so upset that they're already waiting for SCOTUS to listen to this. So here is some reaction. This guy's a former Mueller prosecutor, and so they brought him on to whatever station this is, more CNN. And you can even hear from this anchor. She's like, wow, Jack Smith is really fighting this one. Well, he was successful, right, in keeping the Presidential Record Act being used as a basis to dismiss all the charges. But that really wasn't going to happen anyways. And Judge Cannon has given us some serious insight into how she's thinking about how this Presidential Record Act applies and the discretion that she's giving to the presidency in her initial formulation here. So this is what they're saying in reaction.
This is so interesting here. I have to ask, how unusual is it for a prosecutor to do something like this and just be so pointed in a filing like this with the judge?
It's unusual on top of unusual. Like the fact that we're talking about jury instructions in a case where we don't have a trial date, like that alone is unusual. And I think what you're seeing in terms of the sort of harsh tone in the government is the fact that the judge is asking for jury instructions on an issue that is dispositive. Like it actually, and the government says this, it would determine the case. You don't need instructions, just determine it.
That's right. So walk us through this, the jury instructions and what is happening and what this decision is.
Yeah, and so part of this is the frustration of rewinding, which is the issue before the court is an issue that the defendant raised, which is you should dismiss this case, dismiss it outright, because under this Presidential Records Act, removing these documents from the White House made them personal and I cannot be charged. And that would be dispositive. The government actually agrees if that is in fact the right interpretation.
Yeah, and it is the right interpretation.
The verdict should be directed to the defendants. Rather than making that decision, the judge is sort of, I think, wrestling with how important that decision is. Because think about the other way, which is if the court rules against the former president, this has been his central argument in filings and in public, which is, I have the right to do this. And if she rules that he doesn't, then it deprives him of that argument. And so it's looking for some sort of Solomonic compromise. The court said, well, maybe we can handle this in the instructions to the jury. And what the government said is, there's no reason to do that. Just decide it now.
Yeah, well, they don't want the jury to hear that, because if the jury hears that, they'll find Trump not guilty. That's why Jack Smith is whining. Even CNN's like, wow, this dude has really kind of lost it. Elie Honig says, just take a breath, bro. Relax, okay? Sheesh, we'll get those instructions later. So we'll see what happens here. We'll see if Jack Smith appeals it. Go ahead, appeal it. See what it does to this case, okay? It'll delay it even further. So we'll see what he does, my friends. We're going to be here continuing to cover this, the Florida classified documents case. Thank you for joining us as we do. We got some great links down in the description below. We'd love it if you come over and join us for Sovereignty Saturdays, starting now at watcherlodge.com. All free. We're going to hang out, talk about some sovereignty and self-development topics, news stories, links, alerts, shares, all sorts of cool stuff. So come join us, watcherlodge.com. And we'd love it if you'd invite someone that you know or love. Come on over here and join us. We know that YouTube doesn't amplify, doesn't elevate or promote anything that they don't consider to be authoritative content. That's not us. So we are very grateful when you invite someone over here. Thank you for doing that. We'll see you back here on the next one. All right, my friends, and we got one final segment on the day. And this is an interesting one as the trial gets closer. Very curious. Judges, now we know, colluded to schedule trial dates against Donald Trump, racing to get him convicted before the 2024 elections so they can say a felon is running for the Republican nomination and running for the presidency, and they can use that in their political campaigns and so on. But there is a background here. There is new news that there was collusion between Judge Juan Merchan and Judge Chutkan in scheduling these trial dates because, as we know, Trump got charged with 4 different criminal cases in 4 different locations, all in 2023, simultaneously back to back, one right after the other. So in 2024, when they tried to schedule their dates before the election, there was this question, who goes first? Many of these are going to be 2 months, 3 months, maybe 6 weeks. So there's only so much time. And so Judge Chutkan was the one who came out first. Remember, her trial was scheduled to already have been started until Trump appealed her on the immunity issue, which is now at the Supreme Court. But when her case got deviated, they slotted Judge Juan Mercan's right back in front. They got 4 different eggs to play with. They moved him front. And he was already delayed for a while. And so this is a new filing that is now public. This was submitted some time ago in this case, but Todd Blanche posted this over on his website at blanchelaw.com, where you can find all of these filings, because he is making them publicly available for us to read, because the court will not do that. So we pulled this from him, and it literally is from Trump's attorney. So you'll see this. This is the signed affirmation of Todd Blanche, and he's explaining to us what he has seen. Now let's take a look at this. He says, first of all, we want a reconsideration of this trial date because there was collusion to schedule this, but also we want your ex parte communications, Judge. This is going to Judge Juan Mercan in New York. We want your ex parte, your private third party communications, or not third party, but not single party, essentially, right? Not both sides. The judge should be talking to both sides. Why are you having external conversations with Tanya Chutkan, the J6 judge there in the DC courts? They want to know what those conversations were, and they want them to be documented on the record. Signed by Todd Blanche. And again, all filings available, blanchelaw.com. Check them out, spread them around like wildfire. We got this one from Todd Blanche. He says, all right, look, this is my affirmation saying that we need to get this collusion on the record. Says, look, I represent Trump in this matter, and I submit an affirmation saying we need to get the record of the substance of the ex parte communications between Mercan and Chutkan documented. Saying my affirmation is supplemented by my personal knowledge and my personal belief I represent Trump in multiple cases. In particular, this includes my participation in court proceedings and other aspects of the case. And for the reasons set forth below, I think that your communications with Judge Tanya need to be documented because they have prejudiced Donald Trump insofar as these communications have resulted in trial schedules that are fundamentally incompatible with Trump's rights. Blanche says, look, Judge Juan, as the court is aware, trial in the above captioned case scheduled to begin on March 25th. Now, this was filed earlier, so now it's the 15th, right? The judge postponed it 3 weeks. Thanks, Judge, after they dumped in a bunch of discovery. Now, May 11th was when that got scheduled. Now, since scheduling the May 11th, the trial date back in May, okay, so Bragg's case got scheduled for trial in May. So just think about how all this got moved. Trump has been indicted twice by the special counsel. Grand jury Florida, grand jury DC. In the Florida case, that trial is scheduled to begin on May 20th. Probably not. And Cannon was aware of this. Now, at August 28th, this is where some of the collusion comes in because they're trying to jockey these around. At August 28th conference in DC, Judge Chutkan, she set a trial date for March 4th, which is come and gone. Judge Chutkan was also aware of the trial schedule set by this court, and the March 4th trial date was over the strong objection of Trump. Now, the DC case, they say it's going to take 6 weeks, and that estimate does not include jury selection, opening, summations, defense case, jury deliberations at all. The J6 case is 6 weeks just from Jack, not even the defense. Time is there. Now, although the exact length of the DC case is impossible to predict, likely that it's going to last more than 2 months. So in both written briefing and at oral arguments in the DC case, counsel for Trump alerted Chutkan to my obligations as lead co-counsel in this case. So saying, hey, Judge, so Blanche is in 2 places. No, another attorney in Chutkan's courtroom alerted Chutkan to Blanche's obligations in New York, as well as Blanche's representation of Trump in Florida. Now, Chutkan acknowledged the competing demands and still set the case to start on 25th. No, actually knowing that this was scheduled on March 25th. So in other words, Chutkan put hers first. right? March 4th, they said, no, we got one March 25th. And during that, right, we're wondering, wait, we can't be in two places at one time. So Chutkan scheduled hers for the 4th, and the judge in New York scheduled his for the 25th. So back during the hearing, Judge Chutkan also indicated, she said, well, I did speak briefly with Judge Mercan to inform Judge Mercan that she was considering a trial date that might overlap with this case. Okay, so these two judges are talking with one another. And it's interesting to see how this all unfolded. And I remember that, right? So the trial date was scheduled first in New York. Then Chutkan said, no, I want that block. And then they moved the New York case. They said, perfect. The J6 case, that has priority. You can have it. Now, so they talk. Okay, so Chutkan and Mercan are having this conversation. And they give us some background on this. Here you see March 4th, 2024 trial date was over the strong objection of Trump. That was in the Chutkan case. Now, it's been crazy, the amount of preparation that they've been required to do. They say it's been extraordinary. In the D.C. case, where Jack's office continues to produce discovery, Trump has gotten more than 8 terabytes of data, 13 million pages of discovery, grand jury testimony, hundreds of interviews of witnesses. Similarly, this case in New York has more than 2 million records, insane, spanning 10.5 million pages. They're burying them in discovery, potential witnesses, connection with overlap. This case has been going on for years. Notably, Bragg has indicated that further productions will be made on an ongoing basis, and we've got a lot of other work to do, and nobody cares. They say despite this, and despite Trump's objections that a March 24 trial date's inconsistent with Trump's due process rights, Chutkan didn't give a crap, scheduled it anyways on March 4th. Now, Todd says, now because Judge Chutkan's ruling created a clear conflict with Your Honor's schedule, I wrote to you, Your Honor, on August 30th, which we have not seen, respectfully requesting a status conference to discuss the scheduling conflict that has arisen. I attached a copy of my letter in case you forgot. Now, after initially agreeing to a status conference, you agreed that it was appropriate. Judge said, and again, we haven't seen any of this stuff on the docket because the judge won't put it on the docket. After initially agreeing that a status conference was appropriate, Your Honor replied to my letter declining my request. You stated, in light of the many recent developments involving Mr. Trump and his rapidly evolving trial schedule, I do not believe it would be fruitful for us to conference on this case to discuss scheduling. We'll have a much better sense in February whether there are any actual conflicts, and so we'll see then. Now, under Your Honor's order, President Trump and his counsel must simultaneously prepare for 2 trials in 2 separate courts with 2 separate charges, facts, and witnesses that overlap with each other, and we must wait to address the currently existing trial conflict until February 15th. Now, in light of the untenable conflict by this, Trump asks for a new hearing, and Trump also respectfully requests that you inform the parties, right, Judge? You and tell us of the substance of the ex parte communications between you, Judge Mercan, and Judge Chutkan concerning the competing trial schedules so that you can actually add them to be a part of this case. And reconsider your reasons for not postponing this. We need a new trial date. If you don't give us a new trial date, it is going to jeopardize Trump's right to a defense. Trump doesn't have the ability to even adequately assist in his defense. He doesn't have the right to assistance of counsel since we can't review all the materials needed to do our jobs, or his right to be personally present. Now, the constitutional guarantee is fundamental. Sixth Amendment says we have these rights. A lot of case law here. And interfering with this is a problem. As a constitutional matter, we also have the right to be present. And so counsel and President Trump acknowledge, and we respect the importance of judicial efficiency. We know that judges talk and move things around, but counsel and Trump are not seeking to inappropriately delay this at all. But it's undeniable that Chutkan's decision to set a trial for March put Trump in a precarious position. By her own account, she's well aware that by scheduling the DC case for trial, this is now off, She was literally creating a conflict for him, right? The fact that that trial date got moved doesn't mean that Chutkan wasn't trying to override this judge and was like Chutkan was knowingly creating a conflict for the president, knowing that another court had scheduled a trial, right? So why did Merchan give way to Judge Chutkan? Could it be because she's a federal judge, because it's a DC case? He called it yesterday in his proceeding, his filing, the federal insurrection matter. Does he think that's more important in this case? Like, what's the substance of their conversation? What did they say? While noting the conflict, Judge Chutkan acknowledged, as she must, that, yeah, Trump does have a right to be present at both trials, as well as the commitments and the obligations of his counsel to prepare for them. Now, despite this, and despite her so-called brief, discussions with you, Merchan, about these trial schedules, the trial in DC is scheduled to begin 21 days before this one, right? Like, they did that intentionally. Then they moved him around. So she scheduled his, then he moved theirs. Then Court of Appeals took up the J6 case, and so this one's back on. And Your Honor has denied counsel for Trump the opportunity to discuss this critical case until recently. So the court's decision is a problem. It calls into question whether Trump will have a fair trial, since you two are colluding to stack his trials on top of one another. Trump has 8 terabytes of data to review, grand jury testimony, hundreds of witnesses, SEPA filings. We got Florida. We got numerous motions, deadlines. It's insane. We got 10.5 million pages of discovery, the volume of which is going to continue to grow, and it's all being dumped on us last minute. And so counsel recognizes that you're intending to proceed on this going very soon. Even if it's competing with Chutkan, it's totally inappropriate to even do this to us. And waiting until February to discuss another trial date and see what happens, Your Honor is aware that it would be a waste of court resources and other people to begin preparing for this, not knowing whether it's going or not. And finally, it's inescapable that the circumstances before this court today are colored by Your Honor's discussions with Judge Chutkan prior to her ruling. This judge keeps talking to everybody, man. He has the Office of Judicial Administration just act as PR extensions of his daughter. He goes and gives interviews with the media, talks about the case, even though Trump's defense said, hey, can we have a hearing on pretrial publicity? The judge said, nah, we'll talk about pretrial publicity after I'm done with my pretrial publicity. You know what I mean? So they say, Your Honor, ridiculous. The judge shall not initiate or permit or consider ex parte communications or consider other communications made to the judge outside the presence of their parties about the proceeding. Don't talk outside the courtroom or outside the parties. We want to hear what's being said. And although there are some enumerated exceptions, including one exception that allows the scheduling and other administrative purposes, the rules say the judge should generally disclose the substance of those communications with their parties so that we can see what you're talking about. And again, right, if this is all above board, if there's nothing nefarious that they're talking about, and we don't have anything to worry about, why wouldn't they just publish it? They don't want to even publish anything. The defense objects to these ex parte communications with Judge Chutkan, as they appear to have impacted Trump's constitutional and statutory rights and will prejudice him severely if you don't move the trial, or at least timely discuss the possibility of the adjournment. Now, we understand from Chutkan that she informed Your Honor that she was, quote, considering a trial date that conflicted with you. Now, beyond that representation, we are not aware of what Your Honor stated to Judge Chutkan or any other communications between you two. Now, as a matter of fairness and to ensure the record is complete, we respectfully request that the court inform the parties about the substance of Your Honor's communications with Judge Chutkan. Signed by Todd Blanche, an affirmation for him saying, put it on the record. And of course, that is not going to happen. The judge has already denied making these public. Said, we've already made enough public. You've gotten enough. Here's an email that came in. This one looks like it's from Susan Hoffinger to the judge. It says here, hey, dear judge, per your request at our court appearance, the people have conferred with the defense about a trial date. We're prepared to start in February. March 25th, says the people, this is from Bragg's team, will be ready. And this is from the judge back to Hoffinger. Says, counsel, although the date proposed by the defense provides much more time between decisions on motions than is necessary, this matter is hereby set for trial on the 25th. Now it's on the 15th. All parties, including Trump, are directed to not engage or enter into any commitments that will prevent you from starting. That this is a date certain. Please be advised, the court will not consider any change of counsel unless they're also available to start on the 25th and continue through unabated. Thank you, the judge. Joe Tacopina, many other things. You're on the case. You're on the case. So, right. So that's what came in, and it's now public. So you can see, right, how these judges are just orchestrating this to get Trump. They want to make it happen, and they're working hard to do it. So this is Alan Dershowitz. He's right next door on YouTube, on Rumble, on all the places. And he was asked about this, and he's been practicing law quite a bit of time. And here's what he says about what's happening there in New York.
This is the weakest charge I've ever seen in my 60 years of practicing and teaching criminal law. It's a made-up case. There's nothing to it at all. But there may be a conviction because it's New York. And in New York, they'll convict a ham sandwich if it has Trump's name on it. The case should have been moved out of New York City into Rockland County or Staten Island or some other place where there's a chance to get a fair trial. But gag orders are presumptively unconstitutional because they involve prior restraint. And the First Amendment doesn't permit prior restraint. There's a narrow area where you can have a gag order where you're going to disclose evidence that shouldn't be disclosed, or you're going to tamper with juries. But here's a case where this judge is making a decision helping his own daughter. What could be more of a conflict? And wrongly doing so, this young woman who is an adult and works for a political Democrat company that represents Adam Schiff, the man who headed the Judiciary Committee efforts to impeach Trump, will benefit financially if Trump is convicted and will lose financially if Trump is acquitted. So he certainly has the right to make that public. He has the right to defend himself in the court of public opinion, more so because this is New York and it's a rigged case, essentially, and he's entitled to do that. And I hope his lawyers appeal the gag order, and I hope they appeal the recusal order.
All right, so we'll see if that happens or not, but that's Alan Dershowitz. Make sure you're giving him a follow on all the platforms. I think a good take there. Absolutely rigged, and the judge is no better than Engoron. Actually, maybe worse than Engoron. Engoron didn't have a daughter that was working and raising money for Trump's opponents, as far as we know. But we're going to be here continuing to cover this one as well, my friends. Trump demanded a new trial date. I'm not so sure that's going to happen. The Court of Appeals, someone is going to have to come and take this away from Judge Merchan, and the clock is ticking. We are going to be here to cover the New York trial. It's very likely going to be reading through excerpts and other people who are in the courtrooms reporting on it live, since it will not be televised. And so we'll be here covering it. I do hope you join us as we do. Would love it if you invited someone you know or love to come over here and join us when we go live, come watch some of this content so that they can see what's happening behind the scenes in this case and the others. We got great links down in the description below. Watchingthewatchers.locals.com is our members only community where we dive into other political issues, other cases, other topics, 2024 and whatever else is happening out there. We do streams in the morning, streams on Saturday. We have a great members only community. We'd love to have you. And we have Sovereignty Saturdays now at watcherlodge.com, all free. We're hanging out for about an hour, 45 minutes or so, talking some sovereignty and self-development things, hitting the highlights, checking out what the latest alerts are from our various government entities, and trying to learn some stuff and have some fun community built in the meantime. So check out the links in the description below, my friends. We'll see you over there and back here on the next one. All right, my friends. Well, that is it for us on the day. We had some good filings today. Judges colluding to take out Trump. We've got Jack Smith and his demand of Judge Cannon being rejected, and Sadow responds to Judge McAfee and his denial of Trump's motion to dismiss based on the First Amendment. We are going to go over to watchingthewatchers.locals.com for our after party here in a bit. But now, my friends, let's hear from you and see what you have to say about all this. Very grateful for your support, and I see some good, nice new membos in the house, including Veronica N. Veronica N is joining us. Very nice to see you, Veronica. Welcome aboard in the house as a new membo on the YouTubes, Veronica N. We got Patrick P. What's up, Patrick? Says, Rob, fix your comment settings because it won't allow me to post a super chat with no cussing in it. But you just did. You just did, though. Unless there's profanity in there that I'm missing, I think you're successful. I think you did it. Well done, Patrick. Psst, job well done. Mission accomplished. Here, let me fix it for you. But done. Welcome. All right, thank you, Patrick. We got E. Harris says, all right, I took 40 or so investigative posts about the Mercans and put it in one report, posted it in the comments. So first of all, thank you for doing that, E. Harris. That sounds amazing. I'm going to take a look at that. I'm working on slides. We're going to have a nice slide deck ready to go before the Bragg trial starts. That's going to synthesize everything for us. So that's going to be useful because I'm still working on the Lauren Mercan section. Leanne says, I watched Viva this afternoon and he says Jack Smith has a look like he smells. I nearly spit out my coffee. Shout out to Viva. Says, LOL, Jack should merge with Crazy Eyes. I think he probably does stink too. Yeah, he probably has, kind of like a moldy, like a mildew smell. Like you ever leave a blanket in the washer for too long or something like that, or a towel in the washer, it has that kind of that moldy smell. It's like, you just have to wash it again. It's like, just take a shower, Jack, right? It's not unusual for prosecutors. They're just disgusting. We've got this from, Hey Ray K says, I finally figured out who Rob reminds me of. Count Floyd of Monster Chiller Horror Theater. I don't even know what it is. SCTV. Rest in peace, Joe Flaherty. Rest in peace to Joe Flaherty. I don't know who that is. Count Floyd? Sounds kind of like a cool dude. Count Floyd of Monster Chiller Horror Theater. Yeah. I can dig it. I'll take it. We got this one from Dolphin Fan is the man, bringing in 5 new membos. We got Wild Bill is coming in. We got Trevor Smith, pound for pounds here, Ed W, Chris Sawyer, and shout outs to Janine S and Maynor for shouting out the Dolphin Fan is the man in the house. Okay, so from Dolphin Fan. Hey, Guess is here, says Robbie G for Trump's USAG. Hey, if I'm called to serve, baby, we'll step up to save this country. Says, watchers, email your House reps now. Let's get Rob Govea on their radar. If I'm called to serve, baby, we'll strap up and ride into D.C. We'll bring the show to D.C. and we'll just see what we get a lot done there, We'll live stream from the halls of Congress. We'll live stream from Merrick Garland's desk. I don't care. We got, hey, what's up? Richard C says, and thank you for the very generous dono, Guess. And Guess, thank you for being a membo. We got Richard C says, Jack Smith reminds me of General Zod. Yeah, from Superman. I can, yeah. Yeah, I can kind of see that. The new ones? Yeah, he stinks, whatever it is. Thank you, Richard. We got this one from Sandy says, Letitia James was interviewed at some international film festival and stated Bragg and Fanny cases along with her case would be delayed to accommodate the DC case. That video is proof that they were all colluding with timing. Yeah, I remember that. And Sandy, did you pull a link up on that one? I think you said you had a link on that, but yeah, I remember, right? They were moving stuff around and we were talking about like moving pieces on the chessboard. I think that was the analogy we were using. We got, hey, it's the Munkets is here. What's up? Tony Hay is bringing in Kimmy G as a membo. YT Lover, Shadow Axe Band is here. Pon W and Mama Rowe, all in the house, brought in courtesy of Tony Hay Munkets. Tony, thanks for doing that. Welcome aboard to our newest of membos. Chubby Stubbies here says, it's becoming more and more clear that either McAfee is biased or he really needs to brush up on the Constitution. Maybe you should be remanded back to law school or something. Yeah, everything that came after the non-disqualification order is sus. Now, moving forward, everything, unfortunately. Joanne K, what's up? 5 months as a membo. Joanne, thanks for being a membo for 5 months, halfway to a baby. Says Trump 2024. Indeed. Thank you, Joanne. Joan, we're gonna be on that train for sure. Mark B says, wouldn't filing false criminal charges against Trump being considered legal? Yeah, I mean, maybe Trump could make that claim and indict all them for indicting him, right? That's how it's going to go if in this new game of political prosecution against your opponents. But, it's might makes right. If you hold the gavel, then what you do is not illegal. If you hold the prosecutor's badge, then you can prosecute. It's unfortunate, but that's how it works. Hey, B. Torn is here, says, lucky you. I had rain, sleet, and snow this morning in New York. Man, it was warming up here in Arizona. It was like 83 today. 83. How fun would that be? Hey, Jennifer. Jennifer's here. No comment, but Jennifer, thanks for the dono. Thanks for being a membo, for joining us here on this amazing Thursday. We got Will Crump says, do you think the fix is in all the way? Well, I guess it depends on how you define the fix, but they're definitely not dismissing these cases. And I have my doubts about whether they'll ultimately materialize into charges. But no, I don't think that they're and remember, even if Fannie does not prosecute Trump, let's say this election season, he wins, right? Trial's postponed until after the election. He wins the White House. She'll still want to keep this alive as a thorn in his side, right? And they'll try to dog his whole first administration with this, first term or second term with this. So yeah, they're not getting rid of it quickly at all. Hey, Rain is here. Rain4EST says, Rainforest Leet says, the more they keep on observing over the trial being before the election, the more they are admitting to election interference, obsessing over the trial. You're right. I think it's pretty clear at this point. They will never admit that, but there were 4 cases all simultaneously. And also think about this too. One of the things that they always say is that, well, Trump has never done something so bad, and we've never seen misconduct like this before. And you say, okay, that explanation might cover 3 of the 4 cases, right? They say insurrection and classified documents, right? They're hyperventilate over those. And RICO is also insurrection, but it's just a state insurrection case. But he's not going to trial on any of those 3. The one case he's going to trial on is a Stormy Daniels payoff case. And is that what they're saying is so historic, so unprecedented? So no, okay, so in the last 234 years, no other president has paid off some person. You're saying Bill Clinton didn't have any potential problems there? So Trump's, even if you believe what they say, his dalliance with Stormy, whatever, even if you believe that, that's worth shattering 234 years of precedent, and you're going to make that the big case. Trump is such a monster because of that. It doesn't hold, right? They just have TDS. One of those things is not like the other. You could make the argument, wow, end of Trump's administration was crazy. It was chaotic. And maybe there was some, enhanced criminality there that you haven't seen from other presidents. I would disagree with that. But even if you gave them the benefit of that doubt or looked at it in a light most favorable to them, they're still dead wrong about that. It's not, all of the conduct is differentiated and they are still prosecuting him. So it's not actually what they claim, which is something unprecedented and historic. All right. So that's from Rain. Thank you, Rain. Good comment. Tony Hay in the house. Bringing in new members. Bringing in Sally M. JS. Royston M. Pa is here. Shaolin F. And Laura. Shout out to Laura and Terry B. And Tony Hay, bringing in new membos. Amazing. Thank you, Tony Hay. Hey, David D is here, says, I grow tomatoes in a gallon jug off my porch, upside down. It's cool to watch them grow down instead of up. Well, David, that sounds pretty awesome, man. Do you have a YouTube channel? That would be pretty nice to learn how to do that. Maybe I'll learn that up on YouTube University. But no, we talked about it on Locals this morning, but I'm sourcing one of those vertical grow towers. And I'm pretty excited about it. It's going to be fun. I'll share it all when I figure it out, once I figure it out. But David D, we got Golden Gaming. 1 year anniversary from Golden Gaming. Thank you, Golden. 1 year, man. Thank you for being a membo and supporting us for the full year. Says, judges conspired to interfere with the federal election. our own judges interfering with 2024. Troublemaker Jonas says Jamaican and Colombian judges equals foreign interference. Oh, I see what you're saying. Yeah, I see what you're saying. Yeah, it's an interesting take. Interesting. Yeah, well, yeah, I don't know. We got Deanne F. What's up, Deanie F? Deanie F just became a supporter over on the YouTubes, and it's great to have you, Deanie. Thank you for supporting us. We'll see you on our member-only streams. Sandy says, it's taken me so long to find this Letitia James interview. It appears to be scrubbed off YouTube. Letitia admits in this short clip, she admits to coordination with her case, Bragg's, DC, and Fannie. And let's just see if we can get this to play so we can get this memorialized here before it gets deleted. Yeah, here's Tish. Let's see what Tish says from Mediaite.
The special counsel has asked for a speedy trial for this. Is
I remember
this going
this
to
clip.
intersect with your case at all? How is everybody going to manage the calendar here?
So in all likelihood, I believe that my case, as well as DA Bragg and the Georgia case, will unfortunately have to be adjourned pending the outcome of the federal case. So it all depends upon the scheduling of this particular case. I know there's going to be a flurry of motions to dismiss, discovery issues, all of that. So it really all depends. Obviously, all of us want to know what this Judge Cannon, is going to do and whether or not she's going to delay this particular case.
Are you concerned about that?
I think everyone is concerned about that. So obviously, it will depend upon the scheduling.
Yeah, and you know that they were colluding to talk about this, and they admitted it, right? Cannon admitted it. I'm sorry. Chutkan admitted it during those arguments that she talked to Mercan. So not a surprise at all. They lined them up like pieces on a chessboard, right? And they're making their moves. So great link. Thank you, Sandy, for sending that one in. This old guy says, one thing is for sure. Trump won't lose any of the crocked judiciary attacks on him because he's got lousy attorneys compared to Merchant, Chutkan, Aragon, Bradley, Fannie, Tish, Wade, and even McAfee can't hold a candle to even the staff of one of Trump's lawyers. Yeah, we're going to see where this goes. He does have some very, very excellent lawyers there who are doing good work, good hard work, and they are facing the federal government. It's like a David versus Goliath situation. So shout out to Trump's team, man. Heroic work. We got Ray K, 26 months. Oh my gosh, almost to our third baby. Yeah, that's right. I had to do the math in my head. You're right. 3 babies, Ray K. Oh my gosh. That's a lot. That's a lot of kids running around here. All right. Going to need to get some help on that one. Hey, Ray K, thanks for being a member, man. Thanks. 26 months. We've seen some serious business. Got some gray hairs after that. Thanks for being here. And thanks for saying hello for 26 months. Awesome. Boopsy says, Rob, can you imagine examples of cases you'd be overseeing as Trump's AG? Wow. Oh, yeah, I can think of a couple. How about this? United States versus Fannie Willis, United States versus Nathan Wade, United States versus Jack Smith, United States versus Jay Bratt, the list goes on and on. Yeah, those are a couple of prosecutions I'd consider looking into. It'd be fun. Hey, B. Torn is here. Says, how can Cannon get canned? Ty Cobb said that she should. Well, he was probably talking to what, Caitlin Collins or somebody? Over on CNN? How about that? They want her to be appealed, and they want Cannon to be recused. So those might be a couple of options. Hey, B. Torn, thank you for that. This one from Paul M. says, should Judge Cannon dismiss the case because of the PRA and Smith never appointed by a president or confirmed by the Senate, then case would be dismissed. Yeah, they dropped a bunch of them, a whole slew of them. And it would be nice. So the one that I've heard most from the people who are in the courtroom that has the most possibility is the selective and vindictive prosecution one. Julie Kelly, shout out to Julie Kelly at Julie_Kelly2 on X, has said that she thinks that there's a real possibility that Cannon dumps this case because others were not prosecuted. Like, why was Trump prosecuted but no other person? Like Reagan, like Clinton, like Hillary, like Joe, like Pence, right? Why? Because they hate Trump. And thank you, Paul. We got Bad Poet. Hey, what's up? Bad Poet says, basic snooping, authentic. Judge Juan Mercan's daughter's company got Facebook in 2018. Judge was appointed the acting justice and never left like in 2009. So the daughter gets a great job a few years ago and huge amounts of money passes through and shifty. All true. Sounds all true to me. That's from Bad Poet on Rumble, who's a membo over on Rumble. Very, very nice to see you, Bad Poet. And so, my friends, thank you so much for sending in those donos. Love that support. And I saw a comment that just flew by. It says, Rob, you're going to owe us some child support on all these babies. And it's, I don't know. I'm probably going to be a deadbeat father over here. I don't know. It's not going to be good here. There's a lot of babies out there. I don't know I can afford it. Let's see what's going on. Yeah, hydroponic. Yeah, hydroponic is the tower, which is the one that I was talking about. It's a hydroponic garden. You can source them for pretty inexpensively on some websites out there. But I'm trying to source it. And if I order it and it shows up here and it all works, it's not like a scam, then of course I'm going to share that with everybody. But let me vet it a little bit first. Hey, what's up, Diane? Diane's dropping some comments over there. Crypto Nerd. Pamela says, where does this leave us? If he gets convicted, can he go for an appeal? And when that's done, the charges won't be official, right? Well, yeah. I mean, look, that's all I think going to matter in the court of public opinion. They just want a conviction so that they can say he's been convicted. Okay, he is a convicted felon. I think it's almost like they're not going to put him in jail. Maybe. But that's their real effort, is to just use it politically. It's a political attack. It's a state-sponsored political attack that's organized, operated, and funded by the federal government, and we pay for it. Alf says, judges didn't collude. They coordinated schedules. Okay, Alf. Crypto, I'm sure. Yeah, I'm sure they did. From two different courtrooms, and they're trying to jockey their calendars. Okay, you might coordinate with the other judges, like who's handling jury trials on Friday or something. But Crypto Nerd is here. Luke is here. This is the end game. They must be confident. Stephens says, Jack Smith talked about adding additional charges. We got Russ is here, says, I'm so frustrated. Either Jack Smith's appointment as a special prosecutor is illegal or it's not. If he's illegitimate, then all his work becomes null and void. Why is this not being ruled on yet? We'll have to ask Cannon on that one. Alfred is here. Joshua Wild is here. We got Cajun Joey's here. Another thing was filed by Jack Smith. Great to see you. What's up, Diane? All right, that is what we've got over on X, my friends. And so if you want to follow us and follow some other people out there on X, check it out at Rob Govea, ESQ. Great place to get out there and connect with other watchers out in the wilderness. And so, my friends, that is it for us on the day. We are going over to watchingthewatchers.locals.com, our members only community where we have live streams in the morning and shows on Saturday. So come and join us. We also have robertgovea.com, which is where we have our newsletter, our merch store, our PDFs are stored there, our show calendar is there, and watcherlodge.com. We're starting Sovereignty Saturday starting this Saturday. So click the link in the description. Come over there and join us, and we're going to learn a thing or two, and it's going to be a lot of fun as we start talking about that stuff. I think it's going to be important. Shout out to our mods and our meme smiths, those who help mod the fort down for us. Keep things nice and orderly in the house. We got Vientikiz Prime, K-Bean, we got Just Cause, Playing Hooky, Ronnie Cole, Zulu, Beyond Geo, Zach Nichols, John Allen, Janek, Dog Digger, Donut Mind Me, and our friend John McGarvey in the house. Our meme smiths are Sleepy Dog Lee, Nathan, N810, and Geegum Geegum, making our place look beautiful. But that, my friends, is it for us on the day. It's an incredible Thursday. Tomorrow, when we come back here, it's going to be Friday. And we're excited about that. And when we come back, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. See you right back here tomorrow. Bye-bye.